All right, so we're going to look now at the modern women's rights movement, which took place in the later half of the 1900s and kind of continues, but to kind of see a shift in the kinds of policies and programs that women have worked together to achieve. What we see in the background here is we see women marching in support of the Equal Rights Amendment, which did not get added to the Constitution, but we'll talk about in just a few minutes here. So we call this period, like, this is kind of called the second wave of feminism and the second wave of the women's rights movement. And this kind of starts taking place in the 1960s and throughout the 1970s. And women who now they have the power of the right to vote behind them, and their organizing is able to achieve quite a few legislative goals. And get some more like solid legal footing for the Equal Protection Clause to protect their rights. And so in the 60s, we saw more pushes for women's status under the Equal Protection Clause of the 14th Amendment. And the kinds of things that we're pushing for are more about challenging like old gender roles and more about like trying to protect women and protect their place in the workplace. And so this is an important shift, and this will have a lot of legislation that that helps achieve these goals here. So one of the first victories in this kind of second wave of the women's rights movement was the Equal Pay Act. So this is 1963. Before 1963, you could pay men and women totally different things. The Equal Pay Act promises equitable wages for the same work. So regardless of race, color, national origin, religion, sex of the worker, people have to be paid equitable wages for the same work. And so that is like codified into law using Congress's power to regulate interstate commerce. And now we'll see kind of the advances of women's rights that move from there. All right, so the big thing here is the 1964 Civil Rights Act. Now, we talked about this in the African American Civil Rights section that we were talking about. So this was passed in 1964, and this banned segregation and discrimination, all kinds of different forms. And so this was the most important piece of legislation, but it also included specific protections for sex. And so one of those is that it bans discrimination in employment based on sex. It also set up the Equal Employment Opportunity Commission, and that was to enforce the discrimination in employment both for race and sex and all of the other protected classes there. So the Equal Opportunity or the Equal Employment Opportunity Commission also has a huge role in making sure that women are able to obtain work and get hired. We have those important court cases we've already talked about. In 1965, we have Griswold versus Connecticut, dealing with right to privacy and birth control. And in 1973, the Roe versus Wade decision dealing with abortion. So these are huge victories before the court. In 1972, the Education Act is passed, and Title IX of the Education Act bans all forms of sex discrimination in any education program that is getting federal funding. So we'll take a look at that in just a second and see what that means for schools. A Pregnancy Discrimination Act, which comes along in 1978, and the Pregnancy Discrimination Act prevents jobs from being able to fire women for being pregnant or prevent discrimination in hiring pregnant women, and all sorts of protections for them there. All right, so one of the big legislative achievements here is Title IX of the Education Act. This is really important and goes into all sorts of different areas of how educational institutions have to handle things. So the words here: no person shall, on the basis of sex, be excluded from participation in or denied the benefits of or subjected to discrimination under any educational program or activity receiving federal aid. So if an educational institution is receiving federal aid, which every public school is, lots and lots of private schools are as well, we're talking about any kind of federal aid here, then they are not allowed to discriminate on the basis of sex. And so this making sure that there are equal opportunities for women in education has led to improvements in women's educational status in all sorts of different areas. One of the most prominent places we see this is in athletics, particularly like high school and college athletics. This has led to big expansions of sports programs to include opportunities for women so that there are equal opportunities there. This also is the basis for like lawsuits or litigation for schools and colleges where where they're not addressing sexual harassment issues. The same is true for colleges that have not properly dealt with sexual assault on campus and kind of don't give the women on campus any sorts of protection from sexual assault or from their assaulters. And so this is the basis for litigation there. And because the wording at the top on the, no person shall on the basis of sex be excluded, this has also become the basis for the protections for the rights of transgender students. And we've had different administrations interpret this differently, but it is Title IX tells the federal government to tell schools that students should be treated consistent with their gender identity. And so Title IX regulates how educational institutions have to handle treating people differently according to sex. And so this covers a wide range of activities here. The biggest thing here would be the Equal Rights Amendment. This was passed in 1971 by Congress. Like, it passed the 2/3 vote to get out of Congress. And what this amendment would say is that equality of rights under the law shall not be denied or abridged by the United States or any state on account of sex. So this was passed by Congress. It was bipartisan. It had Republicans and Democrats voting for it. It had the support of Richard Nixon, who was president at the time, and advocating for this. And it went out to the states, where we need 38 states to ratify this in order to have it added to the Constitution. And in the immediate 5 years after it got out to the states, it was quickly ratified by 35 states, but none of the other states would ratify it. And at the end of this amendment, it says that this has to be ratified within a 7-year window. And so the time ran up. And the time ran up in 1982 for this amendment to be ratified. And so not enough states had approved this. And so it is not added to our Constitution. But since then, since 1982, we've had 3 additional states ratify this amendment. So in 2020, Virginia became the 38th state to vote to ratify this amendment, which means we've had enough states ratify the amendment at this point to meet the requirement, but they didn't ratify the amendment by the time limit that was written into the amendment. So this is an issue that will probably get before the Supreme Court, and the Supreme Court will have to decide if this gets added to the Constitution or not, because they will have to decide if, when you write an amendment, if you can add a ratification deadline for that. You guys may remember, it's been a long time since we talked about it, but the 27th Amendment, the most recent amendment to the Constitution, was proposed in 1789 and ratified in 1991. So about 200 years to ratify that amendment. So we'll have to see what the Supreme Court says about the ratification of the Equal Rights Amendment and if it would get added to the Constitution and give women the strongest level of protection from discrimination on account of sex. All right, we're going to run through some court cases and talk about women's rights at the court, women's victories before the Supreme Court here. This, in the picture here, this is a very young Ruth Bader Ginsburg as a lawyer, and we're going to go through quite a few of her cases because she became very well known for advocating for women's rights before the Supreme Court, usually by using male plaintiffs to do so. But we've got a few cases to get to first. All right, so it's up to the court to interpret the Equal Protection Clause of the 14th Amendment and decide exactly how that's going to impact women and protect them under the law. And so our first case of gender discrimination that gets to the Supreme Court, where the Supreme Court recognizes gender discrimination, is Reed versus Reed. This was out in Idaho, and so there was this couple that was married, and they were separated, and their son died, and so it was time for them to like settle the estate, like to deal with his will and his belongings and all that kind of stuff. And Idaho's law in 1971 had the words males must be preferred to females. So like when there are options of males and females as the executor of the estate, it was automatically a male. And so the Supreme Court has to decide if that is consistent with the Equal Protection Clause. Is that a form of gender discrimination? And we've got a 9-0 decision here. So everybody agreed that this is an obvious form of gender discrimination and that the Equal Protection Clause, for the very first time, is used to justify a claim against gender-based discrimination. So Reed versus Reed is a big deal. This is the first time the Supreme Court uses the Equal Protection Clause of the 14th Amendment to protect women's rights. Our other super important case here, Craig versus Boren. This is what invents intermediate scrutiny. So this is a very important case because it becomes the basis for all other sex discrimination cases here. So any gender-based discrimination case, because of Craig versus Boren, is subject to intermediate scrutiny. Now, what was going on here? This is pretty goofy. This was in Oklahoma. Oklahoma had a law that for men to buy beer, they had to be 21. And for women to buy beer, they had to be 18. And that is a silly law with no purpose that I can understand. So the Supreme Court here, they ruled that it's up to the state to prove that there is an important government objective for their policy and that the law is related to achieving that purpose. That is what intermediate scrutiny means. In this case, like, this doesn't make any sense. This is not an important government objective. So Oklahoma does not get to keep their weird different drinking ages for men and women. That only applied to like beer. It was a very, very weird law here. But Craig versus Boren is important because this gives us the intermediate scrutiny standard for gender discrimination cases. All right. This is Ruth Bader Ginsburg's first case before the Supreme Court here. She was an advocate for equal protection of women, and she often found that the best way to do this in the court was by using instances in which men were discriminated against based on their gender. So in this case, we're talking about Sharon Frontiero she's in the Air Force. And at the time, the military gave housing allowances and medical benefits to wives. But Sharon Frontiero could not get those same benefits for her husbands. The military like assumed that like husbands had their own jobs and like that they provided all that stuff for themselves, and so those benefits weren't provided to men. And so Ginsburg argues before the court that this is a pretty obvious violation of equal protection. And the Supreme Court agrees. So the Supreme Court here says that this does violate the Equal Protection Clause because there is no reason for the military wives to get more benefits than the military husbands. And so here we have kind of an extension of the Equal Protection Clause doing more to treat the sexes equally. Couple more cases here. Califano versus Goldfarb and Weinberger versus Weisenfeld. These are both cases that deal with Social Security benefits. And in Social Security, like in the Social Security program, the way that it was set up is that if you were a woman and your husband died, you continued to get his Social Security benefits for your life, because chances were that he was the breadwinner or whatever, and he had paid the Social Security benefits and all that kind of stuff. The reverse was not true. So men whose wives died did not get Social Security benefits coming from them. And so these were two cases about small little details here, but Ginsburg represented the plaintiffs in both and argued that these were violations of the Equal Protection Clause, so that there's really no reason to treat widows and widowers differently in this case. And so both of these policies were overturned, and that these outdated ideas of gender roles did not represent the compelling interest of the state. There's no reason to just assume that men would be the like high income winners in the family, and that the men would not be reliant on the Social Security benefits of their wives. So both of these cases overturned those policies. In Dothard versus Rollinson here, we have a case where the policy is it's not explicitly a policy that like is about sex at all. But what a lot of states would do, or like some jobs would do, is they would have height and weight requirements for their jobs. And if those didn't have anything to do with performing the job, those could be used to exclude a large number of women from the jobs here. So in this case, Diane Rawlinson, she wants to be a prison guard. This story is kind of wild. She wants to be a prison guard, and it does seem like you might need to be of a certain size to be a prison guard or whatever. But these were the requirements in Alabama. Where she was suing, is you had to be at least 5'2" and you had to be at least 120 pounds, which seems very small for a prison guard. These aren't gender-based policies, but they did make it so that 41% of all women would not be eligible to be prison guard here in Alabama. And so the question here is, does this violate the ban on sex discrimination that's in the Civil Rights Act? And the court says yes, that these height and weight requirements are pretty arbitrary. And so arbitrary height and weight requirements are illegal. So in this case, since it's not necessary to be 5'2" or 120 pounds to be a prison guard, there was no reason to keep Miss Rawlinson from working in the prison. All right, in a very recent case here, we have Bostock versus Clayton County. This came out last summer. And Gerald Bostock, he is a gay man, and he was facing a lot of discrimination at work. Like they made fun of him for like a softball league he was in, all this stuff. And then eventually one day they just fired him. And there wasn't like a cause to fire him or anything like that. They just said that like his conduct was like not befitting of the place he was working at or whatever. Now, the Civil Rights Act of 1964 bans job discrimination on the basis of sex. And what Mr. Bostock wants the court to answer here is, does that cover sexual orientation? And so that's the argument that the plaintiff makes here, is that since you can't discriminate on the basis of sex, that should include sexual orientation. And the court ruled yes. The Civil Rights Act, the job protections in the Civil Rights Act, extend to sexual orientation and to transgender status. And so this is an important extension of the rights of all sorts of people to be protected under the Civil Rights Act. And so a further extension of the Civil Rights Act and the Equal Protection Clause and how it deals with sex and gender. All right, that is a lot of court decisions and a lot of legislation that has changed the interpretation of the Equal Protection Clause and changed the amount of protection that we have for women under the 14th Amendment. So now the last thing we've got to do today, we're going to take a look at some of the different regulations for women in the workplace.